We gotta start changing.
Good morning, Richie here. So why are we talking about the unlawful detainer process? Well, actually, we're seeing a lot more notices going out to tenants for non-payment or violating the lease. So I think it'll be very helpful for all of us to review the details of it. And then other aspects, usually most people tend to hire an attorney for the unlawful detainer process. But when doing that, I would say 99% of the UDs probably do not require or pursue a money judgment. And that's just for the basic aspect of making or getting these people out of the property as soon as possible. So I'd like to talk about that. So a couple of questions we'll talk about or address. Is there an exception to the general requirement that a landlord give a 60-day notice to terminate a month-to-month tenancy when the tenant has lived in the unit for 1 year or more? Well, there are some exceptions. What is the procedure for evicting? Well, patience. We'll get into the real details. And then how long does an unlawful detainer action take to be successful? A long time, unfortunately. And then can a landlord just avoid this whole procedural mess and lock the tenant out? Well, no, that's a felony. So keep that in mind when you have angry clients. So just a general understanding of the eviction process, along with the Tenant Protection Act, it's essential for any landlord, property owner, or agent who wants to stay both solvent and out of legal hot water. So think of this as your field guide to not getting sued. So the eviction process, giving notice. When and how may a landlord lawfully evict a tenant? Well, in general, a landlord may evict a tenant who refuses to pay rent or otherwise abide by the terms of the rental agreement. So it is necessary to obtain a judgment and writ of possession from a court of law before actually evicting the tenant. The form of court proceeding is referred to as an unlawful detainer action. The legal equivalent of saying you really, truly have to leave now. Most common circumstances in which UDs are performed, well, the tenant has failed to vacate after giving the landlord notice or after expiration of the lease. And we could refer to this as squatting. The tenant has failed to pay rent, so that's a perennial favorite. The tenant has violated the rental agreement in some way, like running an unlicensed petting zoo out of a studio apartment, or the tenant has committed an unlawful act, waste, or nuisance. So think meth lab. So if you can't reach a satisfactory conclusion with the tenant, you should obtain legal advice before giving the required notice and initiating an unlawful detainer action. So eviction is supposedly an expedited court process, and it causes tenants to forfeit all their rights. So landlords must strictly comply with the guidelines when serving notices. So the translation, close enough for government work, does not apply here. When is an unlawful detainer action appropriate? It is only appropriate after the underlying tenancy is properly terminated. So in most situations, that involves giving the tenant some form of notice. So typically either a 3-day, 30-day, or 60-day notice is used to terminate a tenancy. So a landlord will typically be required to give a 60-day notice to terminate a month-to-month tenancy when the tenant has lived in the unit for 1 year or more. If it's less than 1 year, 30-day notice. 60-day notice if it's 1 year or more. And there's one narrow exception in regards to that 60-day rule. We'll talk about that. So when can a landlord terminate a tenancy? Beginning July 1st, 2022, of course, the laws have changed. If the tenant fails to pay rent, materially breaches the rental lease agreement, or does not fall under the Tenant Protection Act, the landlord may terminate the tenancy. The landlord-tenant relationship or tenancy is created by a contract or lease agreement, but we don't know that. When and how a tenancy may terminate depends on factors such as whether the rental period is for a fixed term or is periodic, for example, month to month, whether the tenant has breached the lease or rental agreement in some way, and whether the landlord as a right under limited circumstances. So if they're subject to the Tenant Protection Act, if it's a no-fault reason for eviction, there's three reasons, such as the owner intends to occupy the property, they intend to sell the property, or they intend to substantially improve the property, all of which are no-fault reasons under the Tenant Protection Act. So they can use those reasons to gain possession of the property. Generally, a landlord may not terminate a fixed-term lease before the lease has expired unless the tenant has failed to pay rent or has violated the rental agreement in some other way. So you can't change your mind once you have a fixed-term lease. That's really what it comes down to, unless you and the tenant mutually agree to terminate the lease. So periodic tenancies, month-to-month tenancies, continue until the landlord or the tenant terminates the tenancy with proper written notice, subject to any just cause limitations imposed by the Tenant Protection Act, and we'll talk about that. Types of notices that you may give. So prior to the commencement of a UD, you can use a 3-day, a 30-day, or a 60-day notice. Under certain circumstances, a landlord may have to give 90 days when the tenant is under the Section 8 program or under rent control. Why is that? Why make things simple? That's our legislature. There's no other reason for it. When is a 3-day notice used? Well, the tenant has not paid the rent. So the classic, oops, I forgot for 3 months scenario. The tenant has violated the rental agreement in some other way, such as subletting to a bunch of gangbangers. The tenant has committed a material breach, such as unlawful acts, waste, or nuisance. Think chicken fights, not the type that you see in the pool. If the tenant has not paid rent, the tenant receives a 3-day notice to pay rent or quick. So the language of this notice gives the tenant 3 days either to pay rent and stay or leave. And you can use CAR form PRQ, notice to pay rent or quit. If the tenant has violated the rental agreement in some way, the tenant receives a 3-day notice to perform covenant or quit. The language of this notice also gives the tenant 3 days to perform the covenant. So, for example, if they brought a pet in without permission, that's a reason to serve this type of notice. So they have to cure the issue, meaning remove the pet or leave. And CAR form PCQ, notice to perform covenant, cure, or quit, may be used for that purpose. If the tenant has broken the law, destroyed the premises, waste, or is terrorizing the neighbors with continuous partying and loud music, otherwise known as a nuisance, the tenant receives a 3-day notice to quit. This notice is unconditional and means get out within 3 days, no appeals, no negotiation, no, I promise to turn down the base. So notice to quit, CAR form NTQ. The procedure for serving a 3-day notice. Well, it must be the landlord, the property manager, or any other person who is age 18 or older can serve the notice to quit or a 3-day notice. So if you have a 16-year-old nephew who's anxiously waiting to help and wants to be paid, that will not be proper service. So types of service: personal service, a copy of the notice is delivered to the tenant personally. I walk up to Carlos and I hand it to him. Substituted service: if the tenant is absent from the premises or his workplace, the notice can be delivered to a person of suitable age and discretion. So if they're not an adult, then that's not deemed to be proper service. And that can be delivered at either the tenant's workplace or residence, and an additional copy must be mailed to the tenant at his or her place of residence. Now, the guidelines suggest first-class mail. I would suggest using registered mail at minimum, something that documents it's being delivered. And then the third type of service, posted mail: if the place of residence and business cannot be ascertained, or a person of suitable age and discretion cannot be found, the landlord can post the notice conspicuously on the property, serve a copy to any resident on the property if one can be found, and mail another copy addressed to the tenant at the place where the property is situated. So if you think about it, you may not know if that tenant is still occupying their property. Mail it to that address, and it's possible they may have a forwarding order with the post office. So they should be receiving it. An improper service is probably one of the most sought after reasons for cases being dismissed. So proper service is critical, as a matter of fact. How is the 3-day period counted? Well, the next day after the day of service is counted as day one. So for example, weekends and judicial holidays are not counted. So if the notice is delivered on Thursday, Friday's day one, Saturday and Sunday do not count. Monday and Tuesday, days 2 and 3. If the tenant were, for example, to pay the rent that's due within that time frame, then they defeated the notice.
Or partial payment?
Pardon me?
Or partial
Well,
payment?
that's up to the landlord to accept partial payment. If they accept partial payment, once again, the 3-day notice to pay or quit is rendered defective. So just think of it as 3 business days. That's probably the easiest way to look at it. Do you have to, as a landlord, if the tenant delivers the funds within the 3-day time frame, do you have to accept the money? And the answer is yes. So there's different aspects of that. Have they been paying by check all along? Yes or no? If they haven't been, suddenly they deliver a check. Well, if you notify them in advance that you will not accept a check, then they cannot pay you or remit the funds that are outstanding via check. So you can decline that, for example. And if the tenant offers partial payment, if you accept partial payment, then you have to start all over again, unfortunately. So I would not consider accepting partial payment, because who knows if they're ever going to pay the remaining balance. And then it's so often we see electronic payments taking place. You need to watch your account. And if the money is sent to your account, you should return it if it's a partial payment. If they deposit the money within the 3-day time frame, which could be as many as 5 days, then you have no choice but to accept their payment, and the tenancy continues. So when is a 30-day or 60-day notice used? Well, when a tenant has lived in a unit for less than 1 year, the 30-day notice is most commonly used to terminate a month-to-month tenancy. So remember, if it's a signed lease, you can't just terminate the tenancy unless there's causation. When a tenant has lived on the property for 1 year or more, a landlord is generally required to give a 60-day notice to terminate a month-to-month tenancy. And you can use CAR form NTT, notice of termination of tenancy. And why 60 days? Well, because apparently the legislature thought 30 days was just too quick and easy. Is there an exception to the general requirement that a landlord give a 60-day notice to terminate a month-to-month tenancy when the tenant has lived in the unit for 1 year or more? There is one exception. And you can give a 30-day notice, but you must meet all 6 aspects or points. Let's go through those. The landlord has entered into a contract to sell the property to a natural person, meaning an actual human being, not your own LLC, not your own trust. Now, me transferring my interest to my trust, for example, that's not going to satisfy the requirement. Or your dog. You can't sell it to your dog either, right? So it doesn't say that in the guidelines. I just thought I'd add that. People treat pets better than they treat people. Yeah. The next aspect, the purchaser intends to reside on the premises for at least 1 year following the termination of tenancy. And first of all, why would we consider reducing the time frame from 60 to 90 days? Usually because the landlord's trying to sell the property, and whoever is buying it may not be an investor and they want to occupy the property. And also another requirement, the landlord has established an escrow with an escrow company. The escrow was opened 120 days or fewer prior to delivery of the notice. Title to the premises is separately alienable from any other dwelling unit. So for example, a condominium or a single family home. The tenant has not previously been given a notice of termination of tenancy. So once again, miss one, then it's a 60-day notice. And I would suggest if you miss one and you meet 5 and you send out that 60-day notice, the 30-day notice, you're going to have to start all over again. It's going to be defective. Must a landlord state any reason for serving a 30 or 60-day notice to terminate a month-to-month tenancy? Usually no, unless required by the Tenant Protection Act. Remember, if a landlord is subject to the Tenant Protection Act, they can only use one of 15 reasons for terminating a tenancy. 3, no fault. 12, at fault reasons, for example, non-payment. Let's say by law, month-to-month tenancy is terminable by the landlord upon the serving of 60 days notice or a 30-day notice if the tenancy is for less than 1 year. However, the landlord cannot be motivated by a desire to retaliate against the tenant for exercising his or her legal rights, such as requesting the landlord repair an item for which the landlord is responsible. So in those circumstances, the tenant may claim the legal defense of retaliatory eviction. Revenge is an approach to never be used in landlord-tenant law. So an exception to no-cause termination of tenancy unrelated to the Tenant Protection Act exists. If the tenant has made an oral or written complaint regarding the habitability of the property, then for the next 180 days, should the landlord seek to terminate the tenancy, the landlord must state a reason in the notice. So in other words, if the tenant complains about a broken heater in January, be prepared to explain any termination notice before summer rolls around.
So retaliation only lasts 180 days?
Yeah, well, remember, if they report you to a governmental agency or they repair something and deduct and you try to terminate the tenancy, no matter what, it's going to be deemed to be retaliatory. So you better have a good reason during the following 180 days if you try to terminate that tenancy once again. So typically, if you're not subject to the Tenant Protection Act, you don't have to give any reason for terminating a tenancy. If you are, so remember that exemption box on the RCJC, if you check the box saying exempt, you don't have to give a reason. If you don't check the box, you may not even be able to terminate the tenancy if you're subject to the Tenant Protection Act. So you have to keep that in mind. And then serving a 30-day or 60-day notice, it's similar to a 3-day notice. Good morning.
Good morning.
So it can be served at any time. Person serving it must be 18 years of age or older. Personal service, handing it to him once again. Some of this is repetitive. If the tenant is absent from the premises or his workplace, it can be delivered to a person of suitable age at his place of employment or at the property. And then another copy mailed, or if you can't find him, no matter where they are, then you might be able to deliver it to somebody of suitable age at the property, post it, and mail it. And keep in mind, email and a carrier pigeon approach are not legally recognized service methods, despite their popularity. So I said email and carrier pigeon because email is not satisfactory delivery, just like sending a bird. So if a landlord or property manager, should they ever give possibly a 3-day and 60-day or a 30-day notice to terminate a tenancy? Well, it's permissible to do that. However, certain courts have found that it's confusing to the tenant and they've dismissed the case. So if you have concerns or if you have the ability to serve both a 3-day and a 30-day notice, speak with your attorney, send one of those notices. Let's not think we're going to cover everything here with delivery of these notices, because you may fail. What if the tenant gives the landlord a 30-day notice but then refuses to move after 30 days? Well, then you can initiate an unlawful detainer action. However, if the landlord accepts rent, it has now become a month-to-month tenancy, whether it's partial rent, as Carlos was asking, or the entire month's rent. So that's a problem. If they don't move out, you can then file an unlawful detainer action. Do you have to give them a notice? No, you don't have to give them a notice because the lease already states that it's terminated. However, if the landlord does nothing and the tenant doesn't move out, certain courts have and the tenant decides, I want to say, and they send a rescission notice about their termination of tenancy. If the landlord has done nothing that would cause them any kind of damages, monetary damages, for example, then it's possible that the tenant could prevail. So we need to move along here. Hire a realtor, spend some money, plan on doing things. Say, I'm going to occupy the property.
What are the costs for an unlawful detainer? like with attorney's fees and court fees.
Well, Mike, you may have been involved in a more recent action. What is Silverstein charging now, just for a basic unlawful
He
detainer
upped
action?
this price, but I think it's around 1,000 now.
Yeah.
It used to be 500.
Yeah, it used to be low.
Yeah.
But that's for an uncontested unlawful detainer action, meaning and that doesn't include it if you hire him to serve that 30-day or 60-day notice, right? So he's going to charge more for that, but it very well is probably money spent because now you've got a professional process server that's actually documenting service of that. But for uncontested one, meaning the tenant doesn't respond, then it's going to be about $1,000. However, if he responds and this guy has to go to court and he's the cheapest guy around, then it's going to cost more. So that's the unfortunate part, because he's going to have to show up at court and he may have to appear a number of times, as a matter of fact.
Yes.
Yeah.
If, you mentioned if the lease is over and it's a month to month, so how the process of that? Can you?
Well, it would become a month-to-month tenancy if the landlord accepts rental payments.
Okay,
thereafter.
for instance, if in the past she was able to do a direct deposit to your
Mhm.
account, so, and that would continue,
Well, you would return the
then-
money.
or you return the money.
Return the money.
Okay, but if it would become month to month,
Mhm.
so is that worse or better?
Worse, in
Worse.
my opinion, yes. So here's one way of thinking of it. We've had a few individuals who wanted to stay for maybe a month or 2 months longer. They really didn't want to leave the property anyways. So but instead of allowing it to go to a month to month, because if that person who occupied the property is there for 1 year or more, at minimum, the landlord would have to give a 60-day notice if he allowed it to go 1 more month. So that means effectively at least 90 days. If you're going to allow someone to stay for another 30 days beyond a 1-month lease term, just sign an addendum extending the term of the lease. So you're then avoiding a month-to-month tenancy, and the lease automatically terminates at the end of the extended period. So you don't have to give them now another 60-day notice.
I see.
So that would be my approach. If somebody wants to extend the term of their lease for some kind of short period, don't allow it to go month to month if you really want them out. It's going to take longer. So, quick overview of the types of notices. Who can tell me which notice is required for a non-payment of rent?
3-day notice to pay or quit.
Thank you. Very good. Landlord wants to terminate the month-to-month tenancy and the tenant has lived in the unit less than 1 year. What kind of notice is required? Very good. Landlord wants to terminate the month-to-month agreement and the tenant has lived in the unit for 1 year or more.
6.
Very good. The tenant has lived in the unit for more than 1 year and the property is in escrow and all 6 criteria we discussed were met. 30 day notice to terminate tenancy. The tenant has committed an unlawful act, waste or nuisance, think meth lab, not messy kitchen. What kind of notice is required? 3-day, 3-day notice to quit, and that's unconditional. It's not curable. The tenant fails to vacate after giving the landlord a 30-day notice or after expiration of the lease. What kind of notice is required? None. There's no notice required. And then the tenant is in violation of the rental agreement. So curable aspects like unauthorized hamsters in the property. Or somebody brings a dog into the property, what kind of notice would you give them? And this is curable. A 3-day notice to perform covenant or quit. So remember how we count days, weekends, and legal holidays. Actually,
So the 3 days notice,
Mhm.
it means if they don't obey with that law, they have to leave.
yes. Yes. You can then file an unlawful detainer action.
And if they don't, so you can do the
Correct. You can do that, right? But if they're violating the law, it's not even a curable event. You just have to give them 3 days before you can actually initiate an unlawful detainer action. So curable act, They have 3 days to cure or to correct whatever the issue is. If they're violating the law, it's not curable. And 3 days passing will then allow you to file an unlawful detainer action.
And when, what would happen then?
Well, then there's going to be a lawsuit filed. You're going to have to actually show that they were served.
So it's a process.
Oh,
It's
yeah.
not something that it happened right away.
No, unfortunately, it takes months.
Yes, yes.
But what do? If you want them out, and we'll talk about the difference between just possession and possession with a money judgment, because possession with a money judgment is going to take a lot longer, and usually landlords just want to gain access to the property and take control of the property. And if you think about it, getting a money judgment, it may be useless anyways, because you may never find these people. So you spend additional money chasing them, you prolong the whole process trying to have them evicted. So that's a decision you would actually have to make. Personally, I would just want possession of the premises and just move on. You can always go back and amend the complaint and try to get a money judgment.
So how can you possess the property while they are living in the?
Well, they're going to be removed, right? Once you get a judgment, then they're going to get notification. There's a judgment. And then the clerk is going to provide the sheriff's department with the judgment in favor of the landlord.
Yeah.
And they're going to post notice that you've got 5 days to leave the property. Now, who knows how long that's going to take them to post that. And then if you don't leave, then the sheriff is going to forcibly remove you from the property.
Yeah.
Would another solution be like a cash for keys type of situation?
You could.
Probably less money than it would be to go through all that.
Yeah, you could. I think the dilemma is when you're handing them the money, are they really out of the property at the same time? I guess it all depends upon the type of person you're dealing with.
Yeah.
This sounds like a pain.
It is.
It is a pain.
Yeah.
Even in that case, sometimes they can, buy like an extension, right?
Extension?
Something that.
Once the judgment is issued, there's nothing they can do. And they can appeal it, but that does not prevent you from removing them from the premises. Once the court issues a judgment in favor of the landlord, they can appeal it, but that does not stop the process of eviction.
Yeah.
I was going to say on the foreclosures, if we buy a foreclosure and there's a tenant in there or an owner, we do negotiate with them to ask for keys. And then when we do it, they have to have it completely empty before we give them the check.
I see. Okay.
Yeah.
Yeah. Otherwise, how would you ever know they're going to move out, right?
And
Make sure the property's vacant.
sometimes when you sell a property or you buy a property, the owner is still want to be at, in that property for a while. And if they delay it, so it can be a process, right?
Sure, you'd have to do the same thing.
Uh-huh.
Give them a notice to actually, if you would have some type of lease agreement signed, right? Seller in possession, if it's 29 days or less, if it's 30 days or more, a residential lease after sale. But once it expires, you don't have to serve them with a notice. You can just proceed with the unlawful detainer action.
Nice.
So if the tenant's fixed term lease expires, but the tenant refuses to move, well, the tenancy or the lease agreement already defines the termination of the tenancy. So the tenant's required to move. But what should we be doing? We should be notifying them at least 30 days in advance that they should be vacating the property. Because who knows if they go to court and they make a claim that they weren't aware. So don't put yourself in that position. And then remember, they have an opportunity no sooner than 2 weeks prior to the termination of the tenancy to perform a walkthrough of the property, giving them an opportunity to cure any defects in the property. And then remember, if the tenant is subject to or the landlord subject to the Tenant Protection Act, it's possible that the landlord may not even have the right to terminate the tenancy. So we'll just continue on. After serving the tenant, then what takes place? Well, the time frame must elapse, whether it's a 3, 30, or 60-day notice, right? And then you can actually file with the court, and there are forms that the Judicial Council has issued and are available on every single website, as a matter of fact. And then you need to have them served. You need proof of service. You need a copy of the lease agreement, for example. And I guess it's possible someone could allow someone in without a lease agreement. That would be very foolish. And then the landlord must sign that under penalty of perjury that it's all true. And if they do lie about service, anything in the lease agreement, it's considered a felony. So after completing the service of the unlawful detainer complaint, the tenants will have 10 days to answer, or more depending upon the type of filing. But we served them with the unlawful detainer action. They had 10 days to respond to that. If they allow the 10 days to lapse, and it doesn't count weekends, then they can actually, if they allow it to lapse, then it's a default judgment that you're going to be given. If they respond, then there's going to be a court date, and that's going to be maybe 3 weeks to 2-3 months later, as a matter of fact. So it depends what's taking place with the court system. During COVID, it was backed up until the following year.
Yeah.
So that's a problem. And assuming you go to court and the judge issues the judgment in your favor, that's great. Can the tenant actually contest it and request a jury trial? Yes, they can. So that's really going to delay the unlawful detainer action once again. So how long does it take? Well, probably 2 to 3 months minimum for an uncontested unlawful detainer action. If they contest it, it's Shweta had one example. It took 2 years.
Oh,
Took forever. Yes, and she was still fighting to the end. Somebody who was at one time a licensed practicing attorney and enjoyed living there for free. So, and for if somebody does request a jury trial, just think of the cost to the landlord. Now you're going to have to give a retainer to the attorney. It's going to be extended. But from my perspective, if somebody did that to me, I don't think I would be offering them money. They're demanding money from you to leave your property. I think I would fight it personally. I wouldn't give them a dime if they're going to make my life that miserable. And then what about property managers? Well, a property manager they themselves can't file an unlawful detainer action, but they can act on behalf of the property owner if they have a properly completed property management agreement.
So it doesn't matter really if you rent your place or you give it to property management, the same thing might happen.
Absolutely. Absolutely. There's no difference, as a matter of fact. And that's why I would say landlords are probably much more particular now than ever, because it's so difficult to get people on the property.
Yeah.
Now, what about the courts? Where do you actually file? Well, you file in Superior Court, but you must file in the county in which the property is located, not where you live.
Unfortunately.
Yes. So if you have property in Los Angeles, it has to be filed in Los Angeles County, not because you live in Orange County. And then we talked about this. If they appeal the judgment, right, the tenant loses. Does that in any way allow them to stay further in the property? No. Enforcement of the judgment still continues, and they can then continue to appeal the judgment.
You mean if they appeal the judgment? So they cannot stay?
No, the landlord can still continue with the eviction. All right, and someone can, even though they've been physically removed from the property, continue with an appeal to the judgment.
Mm.
So I'm awarded a judgment. I'm going to have the sheriff remove you, and you're going to continue to fight me in court.
Mm-hmm.
And then also claims for monetary relief, and we had touched upon this earlier. can you both pursue an unlawful detainer action, meaning possession, and a monetary judgment? You can, but here's the difference between the two. So possession only judgment. Why landlords choose this path? The clerk can process a possession only default faster than a combined default that requires a money prove up. So which gets the writ of possession into the sheriff's hands sooner. So for a default case, meaning someone's not contesting it, a money judgment requires the landlord to prove up the specific dollar amounts via declaration or a hearing, which adds a step and potential delays. So skipping it initially accelerates the lockout. Once possession is secured, you can amend the possession only judgment in the same case to add monetary damages without starting over. However, if you just go for possession only, you don't have a collectible money judgment. So Mike, you've been involved in a lot of these. I can only assume that probably not one included a money judgment. They're probably just possession only.
The foreclosures, yeah, possession only,
Yeah.
but on my regular real estate deals, Silverstein charges, I think, 40% to collect whatever.
So he does also. Do they just go for possession only and then amend the complaint later on to try and collect from the tenant?
That's a good question, actually. I don't know if he files both at the same time.
I say probably not, because the whole idea is just to get
you want
possession
them
of the
out first,
property
yeah.
and get them out. And it's so hard to track people down once they're gone. They don't give you forwarding information. So if you were to file combined possession and money judgment at the same time, you leave the court with one enforceable instrument covering both possession and unpaid rent. So that's a benefit. A money judgment immediately starts accruing 5% simple interest for personal debts under $50,000. And that's for judgments entered after January 1st of 2023. So the clock on interest starts sooner. It does extend your collection window from a 4-year statute of limitations on a written lease up to 10 years, renewable for 5 years, dramatically improving your chances of actually getting paid if the tenant's finances improve down the road, but like following them. Also, if you do get the money judgment, it unlocks the full arsenal of involuntary collection tools, wage garnishments, bank levies, vehicle seizures, judgment, debtor examinations, meaning you're brought into court and you must give all your financial records to the judge, and till taps. Anybody know what a till tap is? It gives the marshal the opportunity to go your place of business and open up the cash register and take all money in checks at that location. Yeah. And then attorney's fees clause. You can actually add fees to the money judgment.
So this is for landlord or the tenant doing all of
For the landlord to collect, yes. If he gets a judgment, a money judgment, he can send the sheriff's department to this person's place of business. Let's assume they're self-employed. Take any money that's at the premises. Money, checks. That's what should happen, right?
And Rolex.
Oh, yeah.
A nice Rolex. I think I'll take that.
If I'm not wearing my watch, you're gonna know why. And then keep in mind, in the current car residential lease, there is an award clause for attorney's fees and costs, but the default language is limited to $1,000 for either party that prevails. So you may consider amending that or tell your client, here's an option. Do you want to increase that? Now, it could work against the landlord possibly, because perhaps maybe the landlord violated the lease agreement, right, with a lockout. But remember, it's $1,000. And the only exception to that is in the event there's a guarantor. The guarantor has unlimited exposure on behalf of the tenant. So how do we remove the people? Well, we said the clerk is going to deliver the writ of possession to the sheriff's department. The sheriff's department is going to post that, and they're going to give them 5 days to remove their belongings. So the last one I attended, 4 sheriff's cars rolled down the street. I'll tell you, it's a real show of force. And they have you stay back. They're ready with their guns. You don't know what you're getting into, right?
You know, if you have somebody that like got a notice and then decided not to live in the property, but has all her belongings there, then what would happen?
You're just going to put it out in the front walkway. And at that time and that time only, you can change the locks with the sheriff present.
But how about if it's in condo? What you think?
Put it out on the sidewalk.
Oh,
Get it out. They usually, when they know the sheriff's coming, not always, they'll remove things, but not all of it. So then you're going to have to remove all the junk. And then other surprises, an area to claim. So somebody, let's assume that the landlord gets a judgment to remove the occupants. And then the sheriff's department shows up and telling them you're going to have to vacate the property. And somebody there says, I was never served. Well, it's perhaps because the landlord didn't know who was occupying the property. So that could actually postpone gaining possession of the premises. So if there's a lawsuit filed to try to evict the tenants and not everybody is named, then it's possible you may have to continue to get the remaining occupants removed from the property. And then what about bankruptcy? So filing bankruptcy automatically triggers an automatic stay, meaning any type of collection procedures are stopped. So you can't give them a 3-day notice. You can't enforce the lease agreement or the rental agreement. So that's in the event they file bankruptcy before you get a judgment. But if you are able to obtain a judgment, then them filing bankruptcy subsequent to you obtaining that judgment will still allow you as the landlord to have them removed from the property.
you know, how about those times that they are subleasing the property?
Or are they doing it with the permission of the landlord?
No.
Then they're
And
in
the
violation of the
people
lease agreement.
that they are leasing, subleasing,
Uh-huh.
they don't know.
Right.
So
I would think that, the attorneys probably, when they are doing this, they're trying to name they may not have the names of the occupants, but I think there's some type of methodology in which it covers everybody there.
yeah.
So,
So
yeah.
in reality, you have to go through court. Or you have to work with the lawyer. This is not the
I would-
process.
This is not something that I would ever suggest to anyone. Just because of the technicalities and the fact that you're taking away somebody's rights. So judges are not going to err in favor of the landlord. So in the event you don't have a judgment against the tenant and they file bankruptcy, you have to petition the bankruptcy court for relief of automatic stay. So there's probably another 30 or 60 days of your time, right? Plus attorney's fees. I wouldn't know how to do it. And then what happens if squatters take over the property? If somebody moves into the property without your permission? Well, you're going to call the police. You're going to give them, first of all, notice to move out. But if the police show up and whoever the squatter is says, oh, no, Richard gave me permission to live here. We have an agreement. The police are now going to call this a civil matter, and you're going to have to go through the unlawful detainer process. Actually, it's called a forcible detainer.
3 days again?
Once again, in this case, it's a 5-day notice
5 days.
to vacate the property.
Because I remember we used to live in Northern California, and then when we moved, the house was empty. But again, they were, like it was a time that a teenager could come and, have a party or something. And once we got a call from our realtor that, this is coming up, we don't know what to do. And then not only that, but it's just created other things like, I have a friend in Poland that she was concerned about the homeless to come to the house and live there. So even like a homeless come to the house, it's a 5 days.
So you have to give them notice, right? 5-day notice.
Even a homeless.
Doesn't matter. Because if that homeless person is smart enough to say, no, you gave me permission to occupy this property, cops are not going to get involved.
Yeah, but so what kind of permission I gave you? I mean,
That's up to them to say. All they have to do is make a statement like that. And that we had an agreement that I could live here. It's that simple.
Yeah, because they're not there to investigate, right?
They're not there to
Yeah.
investigate it. Exactly. They're going to rely on the courts and they're not going to put themselves in the position of violating the law. And then self-help methods for landlords. Can we turn off the utilities? Can we change the locks? Can we throw their crap out in the front yard? No, you're subject to litigation if you do that.
wow.
So unfortunately, self-help methods are not necessarily available to you. People that own the properties probably are upstanding citizens, and they're the ones that are going to be harmed ultimately.
I've heard of some landlords hiring some bikers to politely ask them to leave, and it works.
Not a bad idea. Have any friends you could recommend? We can save some time and money, I would think, some of our clients. So that's pretty much the presentation for today. Any questions about that?
I have a question. How can you, once you have a unlawful detainer judgment, how do you get it on the credit report for the tenant? Because to me, if nobody follows through with that, they could keep on doing it over and over again.
Yeah. And there are certain circumstances which California law changed a couple of years ago, which you can't even necessarily report that.
No.
And then part of the problem that we face today, Mike, most of us use rent spree. We don't even get their social security number.
Yeah.
So we don't even have anything to report to begin with. Now you can actually use the rent screening application or some other method to get their social security number. Otherwise, you have no way of reporting that behavior to anybody. Yeah. So that's a dilemma with rent spree, but then it protects us because nobody can claim that we're improperly using their social security number. Yeah. And if it's a certain type of eviction, you're prohibited from reporting it to a credit reporting agency. And I forgot what the guidelines are.
What's the new form that says to disclosure where you can check the box that you agree to report good credit if they pay the rent on time?
Yeah, the form name I don't remember, but we can actually, if there's a small landlord, we don't have the obligation to do that. I forgot how many properties you must own to be obligated to do that. But maybe that's a way of getting their social without making it appear as if you're doing that to protect yourself. I'll report it properly. I wouldn't know how to do it exactly, but there's got to be some kind of method. All right. Well, thanks for coming, everybody. Good to see you.
Start a company with a bunch of